Welcome to today's discussion. The topic of today's discussion is on common intention and its ingredients under Section 34 of IPC. Section 34 provides the general principle of common intention or joint liability. The Code provides that, when a criminal act is done by several persons in furtherance of the common intention of all, each of such persons is liable for that act in the same manner as if it were done by him alone. Principle of common intention or joint liability is otherwise known as the doctrine of combination in crime or common liability. The object of common intention or joint liability principle is that, every person whose evil intent is to contribute to a criminal act, shall become a party to the crime. The person may participate in a crime either by 1. By committing himself, 2. By sharing the crime, 3. Arranges someone to commit a crime, 4. When he helps the offender. There are certain conditions also. They are a prearranged plan where a prior meeting of minds and consultation between all persons took place, or the crime must have been committed in furtherance of common intention. The desire to commit a crime or developing mens rea is necessary in pursuance of prearranged plan in common intention. Now let's see the essentials to attract the joint liability. 1. Criminal act done by more than one person. 2. The act must have been committed in furtherance of common intention. 3. Participation in some manner in the crime. 4. Physical presence at the commission of the crime of all persons is necessary. It is to be noted that the common intention under Section 34 of IPC requires a prior meeting of minds and that there is a distinction between similar intention and common intention. Section 34 deals with common intention, but not with similar intention. Now let's learn about common object and its ingredients under Section 149 of IPC. Section 149 of IPC provides that every member of unlawful assembly guilty of offense committed in prosecution of common object. The Code provides that, if an offense is committed by any member of an unlawful assembly in prosecution of the common object of that assembly, or such as the members of that assembly knew to be likely to be committed in prosecution of that object, every person who, at the time of the committing of that offense, is a member of the same assembly, is guilty of that offense. Let's examine the essential ingredients of Section 149. 1. There must be an unlawful assembly, as defined under Section 141 of IPC. 2. A criminal act must be done by a member of such assembly. 3. Act done is for the prosecution of the common object of the assembly, or such which was likely to be committed in prosecution of the common object. 4. Members have voluntarily joined the unlawful assembly and knew the common object of the assembly. Section 149 of IPC creates specific offense. It deals with common object. The phrase common object is the central fact on which the liability of persons, other than the actual doers of the act, depends. Here the offense must have been committed by any member of the unlawful assembly. An assembly of 5 or more persons is designated as unlawful assembly. Under Section 149 of the IPC, assembly of several persons must have one or more of the common objects mentioned in Section 141 IPC. The common intention to commit an offense by members of unlawful assembly is not necessary to create joint liability under Section 149 of the IPC. Mere presence and sharing of common object of assembly make a person liable for the offense committed. Now let's see the distinction between Sections 34 and 149 of IPC. Section 34 of the IPC deals with common intention, whereas Section 149 of the IPC deals with common object. Under Section 34 IPC, the actual participation in action is the essential element. But under Section 149 of the IPC, the leading feature is the membership of unlawful assembly. Now let's see the distinction between common intention under Section 34 and common object under Section 149. 1. Section 34 of the IPC deals with joint liability on common intention, whereas Section 149 of the IPC deal with liability on common object. 2. Number of persons must be more than one in case of common intention, whereas unlawful assembly must consist, at least, of 5 persons. 3. Common intention required under the section may be of any type, whereas, common object under section 149 must be one of the objects mentioned as to commit an offense, that is, in section 141 of the IPC. 4. Common intention does not create specific offense but only as a rule of evidence, whereas, common object creates a specific offense. 5. Common intention requires that all the accused must meet together before the actual attack, so therefore prior meeting of minds is necessary in this section, whereas, in common object prior meeting of mind under this section is not necessary. Mere membership of unlawful assembly at the time of commitment of crime is sufficient. 6. Only offense committed under section 34, in furtherance of common intention, is punishable, whereas, members of unlawful assembly under this section are not only liable for act done in prosecution of common object but also for any other act likely to be done in prosecution of the unlawful object. That's all for this video. Click on the bell icon to get notified when we upload new videos. Subscribe for more videos. Visit our website for MCQ examinations and notes on this topic. Happy learning! A video from Law Aspirants Hub.